Can you hear me? No, that's one better. Thanks. Good morning, everyone. I think breakfast, early mornings, and meetings don't always meet and make a great friend for us. Thank you for coming in this early. Delhi is not a city that is known for its early risers. Therefore, we do appreciate you making your time to come here. We have a very interesting panel because we are going to deal with the logos, the ethos, and the chaos of arbitration, and how the 2025 rules of SIAC deal with this and provide a solution. But unlike most of the other sessions, we've got our own tadka to it. It's India first. And in order to take you through this journey and the journey of the rules and how we see the future, we have an eminent panel. The gentleman on my left needs no introduction. He's been a consent custodian in his various avatars, whether it be as a counsel, a law officer, a judge, Chief Justice of this country, and now a private citizen of the bench. In his journey, he has ensured that the discourse with respect to rights and consent are always fostered, but also he's ensured consent is truly organized when it comes to arbitration in terms of his judgments with respect to the group of companies, his course correction in the Supreme Court with respect to two things which had effectively stamped out arbitration in India: the NN Global judgment within 4 by 5 months of the previous one, which had effectively done a full stop, had put arbitration into a coma, and the court judgment, which finally dealt with the issue of conflict and said that it's about time that we find friends who are not too close. With that, I would like to welcome Justice Chandrachud to this panel. Thank you, sir, for coming in. Next, we have Gaurav Khanna. Gaurav, other than being a very close friend and a partner for Chula Bhaturas, is also the Associate General Counsel for Nestle. He's had a distinguished career both as a litigator and a transactional lawyer. For the past 18 years, he has been at the forefront of taking money from me as the guy who sells Maggi with Nestle India, and he's made a lot of it. He has, in this role, supported a pan-India operation across the country on indirect taxes, transactional work, food and tax litigation. His contributions include playing a pivotal role in the successful closure of the Maggi noodles litigation, for which my son was very happy, and steering the implementation of the GST compliance for Nestle, and is actively driving multiple M&A transactions for the company. Beyond his corporate responsibilities, Gaurav continues to share his expertise as a speaker at legal conferences and webinars, making him not just a practitioner, but also a thought leader in the field. Then I have the man who sums up arbitration in Singapore. He's been an institution and has been the predominant practitioner with respect to arbitration in Singapore and has shaped how that market has developed. He has been a pioneer whose awards and teachings have shaped arbitration not only in Singapore, but across continents, and we've had a benefit of a number of those there. He has sat as an arbitrator in more than 350 cases and written numerous awards. His cases include those administered by AA, ICCI, ICSID, CTAC, SIAC, LCIA, KLRCA, PANI, HKIAC, and ad hoc arbitrations. He was designated by Singapore to the ICSID panel of arbitrators since 2013. Professor Bu leads the teaching of international commercial arbitration at the Faculty of Law, National University of Singapore since 1994. He is also an honorary professor at the School of International Law, East China University of Political Science and Law. For his contributions to the development of international arbitration and mediation, Professor Bu has been conferred the honor of the Public Service Star in August 2009 and the Public Service Star Bar in 2022 by the President of Singapore. Thank you, Professor. Look forward to hearing your moments of learning and teaching, but for a different audience. Next, we have Urvashi Pathak. Urvashi is a Senior Vice President and Head Legal at Max Life Insurance, where she leads the company's legal and secretarial function. With extensive cross-sectoral experience across insurance, hospitality, real estate, aviation, and technology, that's a mouthful, she has managed high-stake arbitrations and litigations across multiple jurisdictions, alongside steering complex global transactions and fundraisers. Urvashi is an alumna of London School of Economics and GTS IEU. A published author, she has assisted in co-authoring a book called Escaping the Minotaur's Labyrinth, Principles of Taxation, which was published by Walter Kluwer's, and has written articles on legal and regulatory issues. She is a frequent speaker at leading legal forums and a strong advocate for diversity and inclusion, mentoring women leaders through the industry and organizational initiatives. She also serves on the general body of Vidyasagar, formerly the Spastic Society of India, an NGO based in Chennai. Urvashi, thanks for coming over, and we do hope to see the diversity not just by you sitting there, but through your contributions as well. Last is my good friend Vivek, and Vivek, in his present avatar, is the Registrar of the SIAC. He heads the Secretariat. He has 18 years of experience in international dispute resolution and arbitration. Prior to joining SIAC, he was a partner at a leading firm in Singapore and regularly acted as counsel in international arbitrations conducted under various institutional rules. You would not remember this, but the first set of PAs which were seated abroad were enforced by a team where Vivek was a part of the think tank that allowed for that to be brought to India or onshore that relief. Vivek has also acted as an arbitrator and has been appointed as an emergency arbitrator and to 3-member and sole arbitral tribunals. Thanks, Vivek, for coming in. He's also been involved with the upgradation of the rules, and we're going to get into that in a moment. My first question is, with this focus, we are definitely talking India first. And in that regard, what my first question is to Justice Chandrachud. Justice Chandrachud, do you see whether institutional arbitration has presented itself as a capable alternative to courts, especially the SIAC in its rules and its formulation, including through emergency arbitrators, etc.?
Thanks very much, Vicky. Your question really is to what extent institutional arbitration is an effective substitute for courts. Well, it is, as I will shortly say in a moment. But I look at it as, from a broader perspective, that institutional arbitration is desirable not just because it is a substitute for courts. What institutional arbitration does, and I think SIAC is a prime example, is that it picks up from the positives of the court system. And what are those positives? The existence of infrastructure. Second, the existence of accountability of persons who man the system. And third, the element of having an institutional approach to application. So these are the three facets which institutional arbitration really provides for. But what is the benefit then? It also obviates the problems of courts. It obviates the chief problem of courts, which is the burden on courts. Because the same courts as we see in India, who deal with complex commercial disputes, are also determining as to whether bail should be granted in a rape case. Now, courts have their own priorities because you say prioritize a case involving the grant of bail or personal liberty, perhaps more than commercial arbitration, because the same judges are going to decide that. And this burden on the courts really is a huge problem of the court system, which institutional arbitration seeks to avoid. It also avoids the problems of ad hoc arbitration, which is, the lack of accountability in ad hoc arbitration. So that's the first aspect which we need to really focus upon. The second point which I want to make is that, the arbitration universe is, in that sense, particularly in the context of the institutional arbitration, the arbitration universe is greater than the sum of its parts. We are stakeholders in the arbitral system, whether it's counsel, whether it's arbitrators, whether it's clients. As arbitrators, we look upon our work as providing an efficient and streamlined conduct of the arbitration proceeding. As lawyers, we want to provide the best services to clients in an intensely competitive environment. And clients are the consumers of the adjudicative process in an arbitration or the mediated process in an arbitration proceeding. But what happens is this, and this is where I think the SIAC rules, this is just a preliminary point which I want to make, and there will be other questions as well. What the SIAC rules have done is to highlight, that over and above, the needs of counsel and arbitrators and clients, there is something much wider which is necessary to have a successful arbitral institution mechanism. First, the rules are the product of extensive stakeholder consultation, which you can never have in ad hoc arbitration, and which even courts cannot have, because courts are too hidebound by other requirements of being an organ of the state in the wider sense. Second, the SIAC rules, for instance, would greatly benefit and have benefited by the extensive database of over 3,000 arbitrations which have been conducted. So you have this database, you have the database which provides for not just on merits, the substantive aspects or outcomes of the arbitration, but the database about how the arbitration proceeded. How can you modify the rules to make arbitration more effective? Look at questions like diversity of arbitrators. Now, something which is in the nature of an ad hoc system can never work on diversity, because the two parties choose an arbitrator. And why would they choose someone, say, based on gender or marginalization or sexual orientation? But when you talk of an arbitral institution, these are critical features of the arbitral institution. You've mentioned some of the very critical changes which have been made by the SIAC rules of 2025, and I'm not going to go into them, but I'll just identify them, because I'm sure we're going to be discussing them. First, the importance of preliminary protective orders, PPOs. An Indian court, you go to an Indian court for a Section 9 application and you realize how difficult it is to even get a hearing, because courts are overburdened. Now, of course, the Supreme Court in Amazon recognized that the enforceability of emergency arbitral awards, particularly where it's an India-seated arbitration. Second, the rules have made a huge difference in bringing together a streamlined and expedited procedure. Fast-track arbitration, cap costs, particularly very important in the context of MSMEs, smaller organizations. International arbitration is not about just huge conglomerates or corporate bodies who want to arbitrate. You also have, medium-sized enterprises in India for whom arbitration should become viable. So the capping of costs, limited procedural steps, that's the second thing. The third, which I think I should emphasize, is the third-party funding disclosure in Rule 38, which has been a critical change. We already knew that there was third-party funding, but we've now brought it out in the open. SIAC has to be complimented for bringing this out in the open by providing for express rules in regard to third-party funding disclosures. Fourth, the preliminary determination mechanism, resolution of threshold jurisdictional issues within a time-bound period of 90 days. And fifth, Rule 17, which provides for coordination of related arbitration before the same tribunal. That has a flip side. If one arbitral award goes wrong, everything goes wrong together with it, as we have noticed in recent cases. But just the fact that you have, in today's infrastructural space in India, you find multi-project contracts, same issues, similar issues, same parties, and why should you have different tribunals going into it? So I think these rules which have been brought into force in January 2025 are truly forward-looking, and their impact is not just in terms of the work which SIAC is doing, but they will serve as a paradigm now, I believe, for Indian institutions as well. Indian institutions which can really learn so much from these rules, and I think that's the spirit which SIAC also embodies, that they're not holding these rules close to their chest, but hope that these will be employed in other parts of the global south as paradigms for dispute resolution.
There you have it.
In terms of understanding, I think Justice Chandrachud has literally put it in his usual style. The five fingers come together to make a fist to take care of disputes. Vivek, my next question is to you. What was the ethos behind the overall of the SIAC Rules 2025? And how do these changes effectively elevate the SIAC's status as a preferred arbitration service provider to the world in general, but India in particular?
Thank you, Vicky, and very good morning, everyone. I'd like to say, and I hope you can think of us, the arbitral institution, a bit like the device we all carry around in our pockets. It has a user interface, which for us is the people you interact with, people in the secretariat, people in our offices in India and elsewhere. But it has a software that it runs on. And for us, the software is really the rules on the basis of which we manage, administer cases at the institution. And as with any software, it requires updating from time to time. Way back in 2010, when we introduced the 4th edition of the SIAC Rules, I would say since that point in time, we have been at the forefront of innovating procedures into the rules to provide tools for parties and tribunals to achieve efficiency in the conduct of arbitrations. We were amongst the first institutions to introduce the expedited procedure, which is a 6-month fast-track procedure for small value, low complexity claims in the 2010 rules, and we've had that now for over 15 years and over 1,000 applications for the expedited procedure. In 2010, we also introduced the emergency arbitrator mechanism as a means of obtaining urgent interim relief from a person specifically designated for that purpose, who is the emergency arbitrator. In 2014, we introduced the mediation arbitration protocol, which is a means of combining the benefits of arbitration and the structured mediation process in a dispute resolution clause and therefore in the conduct of the process. In 2016, recognizing the prevalence of multi-party, multi-contract disputes, like Justice Chandrachud mentioned, in the commercial world, we introduced provisions for consolidation of arbitrations and the joinder of non-parties to an arbitration. At the same time, we also introduced provisions for early dismissal, which allows you to strike out claims and defenses that have no merit whatsoever or are manifestly outside the tribunal's jurisdiction. So these are all innovations that have been focused on ensuring that parties can reach a quicker resolution of their disputes in arbitration. So the 2025 rules, from my point of view, is not just an update, but it's also the clearest articulation of our commitment to what I call the 4 E's, and in keeping with the title of the topic, which are the 3 I's. The 4 E's that we think are crucial and must be the objectives of any arbitral process are efficiency, of course, but excellence in terms of the quality of case management and institutional oversight of an arbitration and the quality of the decision makers that are being appointed to arbitrations, and we'll talk about that in just a moment. The third is enforceability. It's because you can go through a process that is quick, that is fair, but if you don't get to an award that is enforceable at the end of the day, the whole process is quite useless. And the last, I would say, is the experience, is the user experience with arbitration, and the focus in the 2025 rules on providing the user-centric arbitration. So these principles are set out in as many words in Rule 3.5 of the 2025 rules, when it says that parties, tribunals, the institution, and everybody associated with the arbitration process must endeavor to ensure the fairness of the proceedings, must endeavor to ensure the cost-effective and expeditious conduct of the arbitration, but proportionate complexity of the dispute, and the enforceability of any award that is made in the arbitration. So in keeping with these principles, of course, we have introduced a slew of new provisions and procedures, like Justice Chandrachud enumerated the 5 key new procedures, being 1, the streamlined procedure, which provides you with the ability to conduct a 3-month fast-track arbitration process for very low value claims, less than about 6 crores Indian rupees, about 1 million Singapore dollars. And even in designing the streamlined procedure, the consciousness was that you do not require a Rolls-Royce kind of procedure for every arbitration. Streamlined procedure is designed to be conducted on the basis of documents and submissions only as a default, and you can introduce means for document production, fact witness evidence, expert witness evidence, or even a hearing only if necessary. So the default is you decide to documents and submissions, and that's our way of signaling that claims of that nature should be conducted in a short time frame and in that particular manner. The second is the PPO, of course, which is a means of obtaining ex parte urgent declarant relief from an emergency arbitrator. And then you have the preliminary determination mechanism, which is again a cue to parties and tribunals to say, consider deciding discrete issues at an early stage, which can contribute to disposition of other issues that may arise in the arbitration. And noting that parties and tribunals maybe are not doing that enough already in arbitrations. So that's our way of signaling to the ecosystem that this is perhaps what is necessary to ensure efficiency. And then you have coordinated proceedings as a further fail-safe against consolidation provisions, where if you cannot consolidate arbitrations, you can at least coordinate them, procedurally synchronize them, and ensure that there is consistency of decision making across multiple arbitrations. So there are of course a number of other changes to the rules which time doesn't permit me to speak about. But all of this is of course based on, like Justice Chandrachud said, our experience with administering thousands of arbitrations under the 2016 rules, the learnings from that, the consultation process that we underwent over the course of over a year, and the guidance from members of our court, including VP, Professor Lawrence Boo here, who devoted their valuable time to deliberating every single change in the rules and considering how that is useful from a user point of view, from a practitioner point of view, from an institutional point of view. And that guidance really defined many of the changes that you see in the SIAC rules today. But speaking of innovation, the last point I'll make is that just 2 weeks ago, we launched a protocol for arbitrations in the insolvency space to allow the arbitration of insolvency-related disputes and disputes emanating from an insolvency proceeding. So we are constantly thinking of ways that arbitration can serve the user at the end of the day, because I think we are quite conscious that we are a service provider in the arbitration ecosystem, and anything that the institution does in the rules, in the procedures, in the processes must answer the 4 questions that parties typically have when they get into a dispute: is how long is it going to take? How much is it going to cost me? Am I going to have an enforceable decision that gives me the relief at the end of the day that I'm looking for? And am I going to have a fair process? So every service provider, we believe, must look to answer those questions in anything you design by way of process or procedure. I'll pause there, VP, and hand the time back to you. Happy.
That's actually a great layout for what went in. But there's always been this thing about fairness and how fairness can be compromised at times. And my question goes to Professor Boo. You've been there in the institutional journey of SIAC, involved in various capacities. During the formulation of the present 2025 rules, how did you balance out concepts like consent, natural justice, and opportunity to a party to present its case, when innovations such as PPOs, streamlined procedure, and expedited procedure were thought of and introduced in these rules?
Thank you. I must say that we should not be addressed to me, but as SEC Court, the President is also here. But the question that we have to consider whenever we make any rule change, any amendment, or any new innovation, they must be user-focused. It must always be the interest of what the parties are looking for. We look for efficiency, enforceability, we look for fair play, we make sure that we always ensure that the parties have the right to decline to apply the rule, for example. They can always opt out. In fact, a lot of all these rules, parties have the option to opt out of them if they should so decide that it's not for them. So, but in also each of these, we make sure that the new innovations to it, I must say that it's always to shorten the process for smaller claims. Like what Vivek said, that not every case got to be treated in a Rolls-Royce manner with red carpet, best services, and the best meals. Not necessary. You got to treat them as what users need. So with that in mind, the rules are crafted following a lot of consultation. And I would say that what Justice Chandrachud observed First, it came from the experience of counsel, the secretariat, who are spanned by one of the brightest, most of very bright lawyers, young lawyers, who are actually working every day, looking at awards, looking at how arbitrators are conducting their arbitration process, learning from their mistakes and their good practices, and putting them together. And then they formulated some drafts and circulated for consultation, getting feedback. They even sometimes interview some arbitrators to find out what the best practices. And of course, gathering all this together, they come up with a draft, and thereafter followed by public consultation with the feedback. It was a very wide, it's one of the widest public consultation I've seen, at least based on Singapore's experience. And a lot of consultation and feedback were given, and they were taken very seriously, because when it was returned, it was then circulated again, and SIAC formulated four many subgroups, teams, to actually debate them. The president was very hardworking. She divided us, make sure we work. Every one of us has, every member in the SIAC board placed in the team. And we have to meet at least 3 times to discuss the various issues that were placed, given to us to discuss. And we then gave our feedback, and then it went again to be reconsolidated, and before it went to the plenary session in the ICC court meeting in 2023, I think. Yeah. So it took a long time, it took a long process. And the whole process to ensure that users come first, and that there's no compromise in ensuring there's fair play. So that is the ethos and thinking behind all this. And let me just add on to what you just said about the I being India. Let me just say that when SIAC came to Singapore, came to India in 2004, 2005, it's almost 20 years now. And when we had our first event here, was a huge event with 500-600 lawyers with the president of India at the time, Dr. Khanna or something like that. Yeah, it was an exciting event, but it was a very it was a sitting event. And look at what happens now. You know? In the early days, when we see ad hoc arbitration in India, we really find that it was lawyers are all complaining. You know? But now, when they get excited about institutional arbitration, about SIAC in particular, I'm very happy, of course, with that. And then as you develop, you find that Indian lawyers are now seen, not just in India, but outside India, in international arbitration. And I think you've got to add that into the plus point of institutional arbitration. It's institutional arbitrations that help Indian lawyers to be appearing in many arbitrations elsewhere, outside India. And I hope one day will come where Indian lawyers will be representing non-Indian parties outside India. And that will be a great leap forward.
I think that's the model that we should take from this room. You have everyone sitting here with some aspiration. That's the aspiration that we should have. A truly international Indian lawyer. You should not just be world famous in India, you should be world famous in the world. And taking this forward, and Professor Wu, you have summed it up very well by saying that there should be a voice and there should be a choice. So my question goes out to my friends on the panel who come from the users. Are you biting all these innovations? Does it make sense for you to look at EPO, expedited procedure, and document-only procedures? I'll first go to Urvashi and then follow it up with Gaurav.
So absolutely, VP. In fact, all the in-house counsels sitting here would agree with me that this is a very welcome move, and the tools that have been deployed by the SIAC 2025 rules have actually fostered this entire bit on transparency, effectiveness, and efficiency. So when we look at the expedited procedure as such, it actually aligns with the business objective of speed and cost. For any company, when there's a prolonged dispute as such, what happens? It erodes not only the cost, but it also has a reputational impact. It has an impact on relationships. So when the issues at hand are narrow and claims are mostly factual, these entire procedures where we can have an expedited procedure or a paper arbitration really works in terms of saving costs, in terms of saving time. Similarly, the PPO that SIAC has introduced again is a welcome move, because imagine getting, like Justice Chandrachud said, getting injunctive relief within 24 hours of filing an application, not going to courts, not going to national courts that you're not used to for a Section 9 like order. And in terms of fairness and transparency, I would say that again, it's great because for getting a PPO, even though it's ex parte, you have to inform the other side within 12 hours. If you don't do so, you are at a risk of the interim order getting vacated. Again, there is a finality there when the emergency arbitrator gives us a word again within a time-bound manner of 21 days. So, absolutely a welcome move.
Gaurav?
No, I completely echo what Urvashi said, and even Justice Chandrachud, Professor Ko, and Vivek. I was just thinking that all the things that I had in mind, I'm getting a score for all those. Because when we look from a business perspective, we are here to do business and not to litigate. That's the philosophy that we have. And in case we have to litigate, my philosophy on litigation will revolve. We're taking some of the 4E's or 4C's is basically it has to be cost effective. There has to be certainty on the procedure, timelines and outcomes. It should be inclusive. It should not be a hanging sword on me for years to come. And then the big point which Urvashi also raised is on the confidentiality of it. So I would not like to wash my linen in open. That's the key thing that we have to keep in mind. And in this Chandrachud, couple of things. We fully respect our judicial system, but there are some little not so great experiences, little sad experiences to share. And I think we have a solve here in the SIAC and other alternate dispute mechanism is to say one of my 7-given applications pending since 2014, and I don't have an answer in-house as being in-house counsel why it is pending, that's not getting decided, or a 3912 application being filed doesn't get decided for next 3 months and then you land up filing a suit for damages. What answers will have? Similarly, as in my earlier affair when I was practicing counsel, in a concession agreement we have an arbitration clause which was running 15 pages. That clause which is supposed to solve the dispute, take up a dispute in itself. Or to give one more example is an interim relief was granted by a high court, and then for me to force the party to enter into an arbitration took us 9 months. But then the arbitration was before ICC in London. It got settled in the next 6 months with clear-cut terms of reference, everything being decided. So I think the issues that we have and these are all for right reasons. It's not that anyone wants to delay it, but there are reasons why these things get delayed. And I think alternate dispute resolution mechanisms sits very well and occupies that space between the gap that what we see here. So, and with as explained very well, emergency arbitration, protective orders will all help business take firm positions and move ahead and do what they are best doing, which is business.
So, ladies and gentlemen, you've heard it from the users, the practitioners. It's not the cost of doing business, it's not the ease of doing business that is most important alone. It's the cost of doing business. And that's what everyone's looking at. So let us check this from Justice Chandrachud. Judge, how do you see it in your view of time? You've acted as a judge, you've now acted as a present day arbitrator. What are your views with respect to a preliminary protective order permitting an emergency arbitrator to grant an ex parte ad interim protective order? Do you think it's kosher for our courts here? Will it meet muster?
When I was a young lawyer in the Bombay High Court, we had this practice of having ex parte applications at 2:45, which was right after lunch. Now, interestingly, though they were called ex parte applications, they were never ex parte. You always served the other side because the defendant was always in Mumbai, which was why it was the original side of the High Court. You served them and you moved your ex parte application. Now, the reason I'm mentioning this is that what the preliminary protective orders really have put into place as a mechanism is that you have first the power to grant relief expeditiously. And that's crucial for users, for parties who are using the system, because there's an urgent need to protect or preserve assets, preserve evidence which may be otherwise destroyed, and third, enforce contractual obligations, make sure that the contract in a given case continues to be performed. So you may have what may appear to be a mandatory order, but really an order which preserves contractual obligations. But equally important as the power to grant relief expeditiously is the power to vary the relief which is being granted expeditiously as well, because you look at it from the perspective of the respondent. And that's why I began by mentioning the time when we were young lawyers. Of course, that gave us a lot of quick money as young lawyers when we didn't have much work, because we could move these ex parte applications. So the power to vary an order which has been passed ex parte and to vary the order expeditiously is equally important to preserve the fairness of the process, which is what the SIAC rule really does. Because my experience as a judge in India was that judges are very reluctant to now grant ex parte orders, because they know that once an ex parte order is passed, it tends to perpetuate itself. We had, just to give you two examples, particularly for our colleagues who are from overseas, we had statutes in India which said that if a case is not heard within a certain stipulated period, the ex parte order which has been granted would be automatically vacated. Now, this was particularly in our financial statutes. The Supreme Court said that this statutory provision mandating the automatic vacation of an ex parte order cannot be enforced, but the party is not at fault. Look, I've got an ex parte order. I'm ready to go on with my hearing, but the court doesn't have time to hear me. So how can you mandate that the ex parte order would stand vacated? Second, in the context of ex parte judicial orders, there was a judgment of the Supreme Court in a case called Asian Resurfacing, which said that if you don't get a hearing on an ex parte order within a stipulated period, the ex parte order would be deemed to be vacated after 90 days. We overruled the judgment, saying again, that how do you blame a party? The party is all ready to go forward for a hearing. But if you don't get a hearing in a court, and then you tell that party that your ex parte order is vacated automatically, that's against injustice to the... So you see, I've tried to sort of highlight to you what the problems in the court system were. So the importance of the preliminary protective orders is both from the perspective of the plaintiff, the claimant. The claimant needs an immediate order for preservation of assets, for preservation of evidence, for preservation of contractual obligations. But equally, there is fairness to the other side as well. Because if an order has been obtained unfairly by a claimant who has sort of overreached the process, because you've heard only one party when you pass the preliminary protective order, it preserves fairness to the other side by ensuring that the respondent has to be served, as Urvashi said, it has to be served within a certain stipulated period, 12 hours, and you can apply for vacating the order. So both aspects, I feel, are critical to the balance, which the SIAC rule seeks to preserve, and which my experience as a judge was that courts are not just able to preserve that sense of balance or fairness towards both sides.
That's a very candid reflection on the position of the burden that our courts have. And rightly so, because we also deal with problems of 1 million people. Now, when there are problems of 1 million and there are disputes of 1 million or millions, my next question goes to Professor Pu. What is your advice to Indian Counsel when you look at the new preliminary protective order mechanism? How should they use it in terms of balancing it out against the right to go to court under Section 9 or wait for the children to be set up under 17? What kind of do's and don'ts or caution tales do you have? Because with great power comes great responsibility.
The power to grant, under the rules, of course, one can, under SIAC rules, you can go to the tribunal to seek the expedited, the emergency arbitrator to get the protective order. Right? So one has to look at whichever is faster, firstly, whichever is faster. If you think going to the courts, whichever court has jurisdiction over the property or over the party, then that might be fast, you know. But probably is faster before an emergency arbitrator and to get an ex parte preliminary protective order. Like what Justice Chandrachud said, it's actually not really ex parte because it is a preliminary order. In other words, before the actual order, the interim measure is given. It is an order for preservation. Hold your hands. Do not call the bank guarantee. Do not sell off the shares. Do not burn it off. You know, that kind of order. So it really does not deserve the label parties are giving, lawyers are giving to it. Lawyers who don't like it call it ex parte. It actually isn't ex parte. It's a holding order. It's a temporary holding order. So I would say that for lawyers, whether in India or anywhere else, the first question you ask is whether it is urgent enough for you to do that. And if it is so, do so before the arbitral tribunal. That was probably, the emergency arbitration, because that's probably the fastest way to get it. You can always go to court, of course, and the court may take time. Whereas in a situation where there's a PPO, the other party, if you are the other party, of course it's fast for the applicant, but the other party, you can always immediately respond and say that we want to come for a hearing, we want to have the application heard. So the respondent can expedite the matter further by saying that we can't have this for more than 24 hours, we need to come forward and have it argued. So there is also the advantage of being applying it to an emergency arbitration. The emergency arbitration should be able to be activated immediately to hear the case. So whereas in court, you may have to get an appointment, we don't know how long it will take. So again, it's all the timing issue. Yeah. So I would say that it's an easy decision for lawyers.
Ladies and gentlemen, that's valuable advice based on experience. Because as they say, experience is a comb life gives you when you go bald. And this comes from a fair amount of experience on why, where, and how you should apply. That brings me to my next question to Urvashi. How can Indian counsel, in your experience, deploy preliminary determination early dismissal tools, which are now present in the rules, to narrow in an efficient manner and achieve your objective of expeditious and cost-effective dispute resolution?
So I would say that both preliminary determination of claims as well as early dismissal are game changers if they're used responsibly and strategically. I have two practical examples. So, when you have these large commercial disputes, you tend to have sprawling claims. You claim for the sun, the moon, the earth, and everything in between. But what happens is when unmeritorious claims are actually pulled out, you realize there's a reality check that happens. So there was this arbitration that we were doing, it was a large arbitration, and there was this preliminary determination of claims that happened, and it made both parties actually realize that they would tend to lose a lot if tomorrow something were to go against them. So we actually asked for suspension of arbitration. Both parties, for 60 days. So both parties sat across the table, thrashed the points out, got to a settlement, signed the settlement deed, and went and filed it before the arbitrator. So in terms of cost, in terms of timelines, in terms of energy, you saved a lot. The other one was a very interesting situation we were in. So when we went into arbitration, we realized that it was governed by the LCIA 2014 rules. And that's when I realized how important it is to actually understand the rules that you're incorporating into your arbitration clause. Because the 2014 rules actually had an aberration when you talk about the joinder of parties. So, which actually got corrected in the 2018, where usually you have commonality of claims, or it has to be between the same parties through the same transaction, etc. But somehow 2014 allowed joinder of parties without meeting these thresholds. And we were in, the arbitration had started, and suddenly out of the blue, there was a joinder application that was filed. And the entities were not related. While the agreement was somewhat similar, again, claims were completely different. And And then the arbitrator had very wide powers to grant whatever he wished. So what happened there was that the arbitrator allowed the joinder, considering that it may have been cost effective for all the parties to be heard together, and the claims can be heard one by one. He recorded the fact that the claims of the third party who was trying to join in was not very clear, so giving them directions on clearly articulating the claim. But at the same time, he also asked the costs of the adjudication of the application to be borne by the claimants. So what happened then was we saw the third party withdrawing the application, the claimant as such also realizing, that the claim that he was making was not, that solid. So all of these aspects again brought us to the negotiating table and settled the dispute. So if we didn't have these BP and, if we wouldn't have used them at the right time, we would have, ended up spending a lot of money, because international arbitrations, as we know, can really bleed you.
That's a general problem, not specific to SIAC.
Litigation is, you end up spending time and money. So it's always better to settle.
No, I think it's a very fair point, and we'll come to that in a moment.
I'd like to note that you just come in here. One of my internal presentations, on litigation, we say, you walk in as a chicken and come out as a sausage.
So when you do that transformation, it's not evolution, it's just revolution. Now, we've seen this, and thanks Urvashi for pointing out the cost and how it can be an aid toward facilitated discussion or a mediated solution. Gaurav, you talked about your 4 C's, and I think we're going to have the English alphabet by the time we finish. In your 4 C's, you've talked about confidentiality. How important is it for you as a client?
Very important, because one example that I gave was the proceedings that happened in London. This matter was on the issue of a disputed patent. None of the parties would like a patent issue to be discussed in open, and especially when the patent is around what impact can it have on the patient's efficacy of both. They like to keep it between parties and not make it public topic. So confidentiality is very important for businesses.
There you have it. When you are looking at advising, what happens in court goes on to various things, including bar and bench. If you don't want the bar and the bench to know about it, the arbitration actually serves as a good method of resolving without dissolving relationships. That brings me to what Urvashi had said, aid to a mediated settlement. Justice Chandrachud, you've always been a strong advocate for mediate, don't litigate. Do you think the SIAC, SIMC, AZB protocol incorporated in the 2025 rules considers mediation and arbitrations as effectively 2 sides of the same coin? Both can coexist to facilitate the object of closure without export. What are your views on that?
I think there's a very critical element in the SIAC rules, which is not to look at mediation and arbitration as 2 disjunct or disjunctive facets of any adjudicated process, but really in that sense correlated. Party autonomy is probably at the highest in terms of mediation. You can, as Section 89 of the Civil Procedure Code in India as well says, you can compel a party to mediate, but you can't compel a party to settle. Because whether to settle, a party may decide not to settle for completely untenable reasons. The choice is of the party not to settle. There may be wages of not settling, which can then of course be imposed on the party later. But mediation in that sense is the completely party autonomy side of the spectrum, where a party decides whether it will be in their interest. And that's why we always believe that mediation is a win-win solution for both the parties, because parties in a mediated settlement get something which is to their mutual advantage. Arbitration perhaps is a little less on the complete element of party autonomy, which you find in a mediation, because obviously there's an adjudicative process also involved in arbitration. But my own perception is that even in the procedural steps, in the processual steps which take place in an arbitration, you emphasize party autonomy at every stage, not just to the point when you enter into the contract, choose the seat or the institution through which you would arbitrate, which involves that element of party autonomy. But even once the arbitration begins, and I think good arbitrators always try and ensure that parties are coming as close together, whether it's in terms of the initial steps, drawing up the terms of reference. Hey guys, hey people, why don't you both sit down together and give us something, as opposed to leaving it to the arbitral tribunal, which you would never see happening in a court. In a court, parties enter through different doors and they exit through different doors. In the course of an arbitration, the emphasis always is on counsel, parties coming together, breaking common ground. Party-appointed experts, you expect the experts to sit together and give you at least some agreed formulation to the extent that an agreed formulation is possible. So in arbitration as well, though parties are moving towards an adjudication, we're encouraging parties to come together to see if there's some commonality of minds, and which eventually would end in terms of a settlement. So I think it would be really, it would be perhaps both reflective of the legal position as well as what happens in the real world of arbitration, to regard arbitration and mediation not as two conflicting terrains, but really involving the basic element of party autonomy, that parties would decide, and if they settle, so much the better. And really speaking, good arbitration processes are facilitated towards encouraging parties to find a common ground, to see to what extent they can reduce the things like how much evidence would be leaked, to reduce the element of conflict and the adversarial parts of the adjudicatory process, and then hopefully encouraging them to resolve the dispute by mediation.
Add on, because to say that I'm actually a born again mediation convert, because I believe that arbitration, litigation, these are like methods of disposing of disputes, whereas mediation actually resolves disputes. So the fact that SIAC Rules actually added or encouraged the adoption of art is a wonderful step forward. And in fact, I as a practice, in my preliminary first procedural meeting, will always add a window in the timetable to set a window for parties to consider mediation. All you need to do is to plant the idea in the party's mind, so that it does not come from the lawyers or from one side. You put it in there as a pro forma and say window for parties to consider mediation. Providing 3 weeks, 4 weeks, doesn't matter, because that will prompt them to say, hey, let's take this time to see whether we're going to consider mediation. So, plant the idea, please.
So from a seed will grow a tree, and if it's your prayer, you should have a say, rather than just leave it to someone else to decide, because you do know what you can live with or live without. And therefore, Justice Chandrachud put it best, it's party autonomy at the highest. You can be forced to go there, but no one can force you to say yes. Vivek, you've heard me say this before. I in SIAC stands for India. What did you have in mind when you set up the rules, which was driven from an Indian market requirement or a specificity?
Thank you, Vivi. If you'll allow me to just look back in time, going back just about a decade and a bit more than that. In 2012, which I really consider as a milestone moment in Indian arbitration development and jurisprudence, we had a ALCO decision, which for the first time in recent memory was a sense of urgency from the Indian Supreme Court to set right the law, to move towards seat-centric arbitration, which focused on what the jurisdiction of the Indian courts, what the role of the Indian courts is in relation to particularly foreign seated arbitration. And that, at least in my view, really provided a huge fillip to to arbitrations involving Indian parties being conducted in places like Singapore. And then the second point, which I think which is very important when we talk about arbitration in India, is the growth in the Indian economy in the last 15 years. I jotted down some numbers, and many of you will know this, of course. The GDP growth in India from 2010 to 2025 is 3 times now, from 1.5 odd trillions to now 4.5 trillion. The foreign direct investment into India in that same period went from about 15 billion US dollars to now at about 70 billion US dollars. And the outflow of investment from Indian companies going outside has remained at about 20 to 30 US billion dollars. Which, and if you follow the principle that disputes will follow commercial activity, it explains why you have such a large interest in international arbitration, why so many Indian lawyers, arbitrators, companies have had experience with international arbitration. And that's reflected in our own experience. In the last decade, we've had over 2,400 Indian parties involved in cases at the SIAC, which has been over 1,400 cases that the institution has received, handled, managed, which have involved Indian parties or India-related disputes. So I'd be remiss if I said India was not a factor in how the rules were framed and designed. Every single change that is made to the rules is certainly made with a view to how an Indian practitioner, how an Indian user, how an Indian court would receive it. And amongst others, of course, you have mechanisms to control costs, to provide cap costs. You have the scrutiny process in the SIAC rules, which has also been fine-tuned in terms of the timelines that apply to it, which is something that we are quite proud of, because we believe it contributes to the quality of decision making and the eventual enforceability of awards that are made in SIAC arbitrations. And perhaps we did a study internally at SIAC, looking at SIAC awards and how they've been received by courts all around, in particular the Indian courts. In our assessment, we have not found a single SIAC award in the period from 2011 to 2022 that was refused enforcement or set aside by the Indian court, which speaks, in our view, to the quality of the decision making, but also the approach of the Indian courts and how that has evolved in that last decade, starting, in my view, from our court. So many of, I think, the provisions, including the streamlined procedure particularly, was also with a view that many small businesses don't bring claims to arbitration because of the perception, like Urvashi said, that costs are high, timelines may be too long. But here's a way of ensuring that those claims can be brought to arbitration, can be resolved, and you have a decision in 3 months.
So now, moving to the next I, which is inclusion under 2025 rules. My question goes to Justice Chandrachud. While you were on the bench, you attempted to spearhead the movement of inclusion in appointment of arbitrators in India on the ad hoc side. Do you think it's time that India welcomes diversity in appointment of arbitrators, and how do you see it benefiting the process?
I'm happy we are talking about inclusion, because in the Trumpian world, the DEI now has become a bad word, diversity, equity and inclusion. But fortunately, we are governed by constitutional values in India. And I'm proud to say that, therefore, I belong to a society where we pride diversity, equity and inclusion, because I feel that's the heart of the stability which we have in India over the last 75 years. Multi-religious, multilingual, multicultural, and yet one nation. And I think that reflects our ethos. I'll just give you a little bit of an anecdote, as I have before. I was talking to a very talented young woman lawyer the other day who had come to me to seek an opinion. And she's head of chambers. And she said a client came to her and took instructions and gave instructions, and they discussed the case. And then while leaving chamber, she said, the client turns to my junior, who happens to be a male lawyer, and says, please do this case very effectively. So she said, this gave me an idea about the mindset. I'm head of chambers. I'm going to be arguing the matter. But he turns while leaving to my junior, who is a male, and says, I hope you'll be doing this well. I'm the person who's going to be arguing it. I'm also asked this question in a country of 1.4 billion people. We have one Supreme Court judge who is a woman today. is there something not fundamentally wrong with the system? Now, there are answers to that, which we'll probably be looking at as we exit from this conversation. But I think it's important that you have to have more women in important positions of responsibility, be it in our courts or be it in arbitrations. And why? I always believed as a judge that having a woman on the bench does not necessarily make for a more liberal outcome. If you feel that having a woman will give you a more liberal outcome, you're wrong, because a woman is entitled to take a view either on the liberal end of the spectrum or the conservative end of the spectrum. You need women in important positions of responsibility in the adjudicative sphere because women bring different lived realities. I think that's the key. That women bring lived realities which a woman only has to the adjudicatory process. And I've sat with women who really enriched my own view of social and economic and political life as we saw as a judge. Just to answer your question, when I was a young judge at the Bombay High Court, we would be hearing these winding up petitions in company jurisdiction where there was no arbitration clause. Small value company petitions were winding up. And I'd always look to the party and say, hey, why don't you go to arbitration? And we'd appoint young lawyers who would then become arbitrators, men and women. And they did a brilliant job about arbitrating. At a time when arbitration was still to catch up. And as a Section 11 judge, and especially in the international commercial arbitrations in the Supreme Court, I made it a point to appoint women lawyers as arbitrators. And I thought that it's important that we change the landscape by allowing for women to have important positions of responsibility. And again, they responded with a tremendous sense of responsibility, taking this up not just as a sort of a professional brief, but something which would change the system by bringing in the presence of women across the spectrum. With legal education having caught up in India and more women, the largest national law schools in India, over 50% of the women, 50% of the new batch of admissions are women in India. At the lowest levels of recruitment to the Indian judiciary, including in the 9 Hindi belt states, over 70% of the recruits are women now in India, which shows you that if you give a level playing field to women, they are succeeding like never before. Now, how do we translate that to ensuring that women don't fall by the wayside as as typically the responsibilities take over? Responsibilities in terms of child rearing, responsibilities in terms of family responsibilities towards aged parents, aged in-laws, the typical Indian family. And this we can do by ensuring that we have more women, and I think that's where institutional arbitration can make a huge difference to the landscape of getting more and more women into the workplace. And these women would then be mentors to other women who would join the workspace. That hey, this is the person I look up to. Women who are good counsel, women who are good judges, women who are good arbitrators. So there's a lot, I think, in terms of diversity that institutional arbitration can really add up to. This is a subject very close to my heart, so maybe I speak with with almost indignation at the lack of adequate representation to women. You have women partners in law firms. You have young women lawyers who are doing brilliantly. You have young women judges who are doing well. I think the time has come to have more women fill up the arbitral space in India as well.
So it's DEI, not DIE, as the Trumpian world put it. That puts me, I know we have come to the end of our time, 2 questions, and I'm going to open it out to the panel in general with respect to the issue of technology. I can start with you, Judge. How do you see the arbitrator becoming someone who facilitates readily the adoption of technology and environmentally conscious practice when they are administering an arbitration? Because at the end of the day, that is one of those hallmarks that have been introduced in the new SIAC rules. And how do you, when you're sitting there, not as a court, because I know you've done that while you were sitting there as a court, to bring in that discipline. How do you bring that in when you're sitting there as a consent custodian to parties who may or may not be willing?
I think my years of experience as a judge have shown me that the adoption of technology is something which institutional mechanisms can do better than any other mechanism. You know, when COVID came down upon us in February 2020, the Indian judiciary, made rapid strides to, having hybrid hearings, to having virtual hearings, live streaming of court proceedings, digitization of caseloads and case management. Now, we couldn't have done this in an ad hoc area. It was only because we had the institutional heft behind us, both in terms of finances, the availability of infrastructure, and we did this completely in an open source platform. We didn't do it in proprietary software. But institutional existence is crucial to the adoption of technology. Now, I think in the arbitration area as well, particularly with the growth of AI, there's so much which institutional mechanisms can achieve. First, in terms of global benchmarking, arbitration requires privacy. So you adopt privacy first as your design structure. Just a couple of things which I have to say on this. Institutional mechanisms can ensure that we will have AI-powered case management, something which ad hoc arbitration could never do. Two, institutional arbitration can ensure, the deployment of predictive analytics, which again is an area which is full of promise in the deployment of technology. Third, something as basic as virtual hearings. I was fascinated in India, where judges who had never opened a computer throughout their working lives are now all on virtual hearings, just because it's become so efficient in cities instead of arbitrators traveling from one end of the city to the other. Great for lawyers, great for women lawyers. We were talking of diversity. One thing which I have heard repeatedly from women professionals, and there's so many of you sitting here, I hope you share my view, is that virtual hearings have really made it productive for women to participate in the workspace in litigation or arbitration. Because you don't spend this unproductive time in courts waiting for cases to reach. And then finally, apart from AI-powered case management, predictive analytics, and virtual hearing, the end-to-end digitization of court records, which we've been able to achieve in the Indian judiciary, I think can go into the arbitral space also. When you have institutional arbitration, like under the SIAC rules. So I think in terms of technology and particularly the deployment of AI, there's a huge amount which can be contributed. And to answer in just one sentence your last point, how do you ensure that parties adopt it? It really depends a lot also on the leadership which arbitrators put into place. As a judge, I found that we were completely paperless in my court, but lawyers would come with huge case files, and I'd always tell senior counsel, why don't you turn back and look at your own juniors who have their own iPads? Come on, I'm giving you a week to make that migration. And I found that a little bit of prod from the leader, the judge or the arbitrator really helps the process. You can't in that sense be a dictator, but you can certainly be a persuader by getting people to, and the young. Honestly, this is somewhere where I think the experienced have to learn from the young, because we have learned to navigate the digital space. Our young professionals are natively digital. They've grown up with technology. So I think for the more experienced practitioners, just take back and allow yourselves to learn from the young people around you. And you'll realize, it's so simple. Technology is meant really for, not for the learned, but technology is meant for people who don't know anything about technology. the back end of technology, that is.
That's very well put. Gaurav, your views on Latin to binary?
I echo Mr. Chandrachud's views completely. For me, thank you very much for making this a reality, because today while sitting in my office I can participate in all the meetings across. There have been many hearings before the tax authorities that I have personally attended and argued matters while sitting in Gurgaon, whether it's Chennai or Calcutta. So a big thank you to you for this, and to me, in my personal view, what it means is justice that goes fair. It's a very, very inclusive thing that I can now relate to my case. I was sharing with people yesterday evening something, whereas young lawyers, we were trained to send out updates on the hearings to our clients, and our standard format used to be said that we vehemently argued your matter and the matter got adjourned. But actually it was, we took a pass over adjournment. So I think it's a big game changer, and it helps, say if it's arbitration in Singapore, London, anywhere, I can participate from there. Everything is digitized, so I don't need to spend. I think sustainability also gets addressed with this, so big thank you, sir.
Professor Bhuva, I know you manage it efficiently.
Yeah, of course, I must say that I agree with Justice Chandrachud, Gaurav's experience. I'm pleased to hear that you find that technology has brought the case closer to you, and without having to travel to attend, you can actually have live feed like this in your office, hearing whatever is going on. I mean, we look back how years ago when I first came to India, my first case in 2004, and how somebody was there typing away, with a typewriter, and always had to pause. And it's so different now. And the most recent one was how it's working like that with no transcribing, no script writer. In other words, no court reporter. It's AI, and someone else is editing it. It's wonderful how India has moved and how the whole technology landscape has changed our practice. Now I used to have hard copies, then with CD-ROM, with USB, and then hard disk, and now it's all in the cloud. We don't need to bring anything except your iPad or your notebook. So it is wonderful, and to hear users saying that it is bringing the case closer to them. They can see all the documents. SIC has SIC Gateway, just like court, they have their case filing system. Now everyone can see, the users, the parties can see for themselves. So it's wonderful. But I want to add something apart from technology, and that is diversity that you shared about. One of the rules, that the unspoken rule that's in the, that's the streamlined procedure, expedited procedure. You may say, what has it got to do with diversity? Opportunity. Actually, it's an innovation that actually secretly there is underlying it. I'm not sure it's intended, but it has got a spin-off there, and that is for young people, young lawyers, young aspiring arbitrators. Guess, are they going to get the cases? No, unlikely. I've always been asked, how do I get into this space as really be an arbitrator? All these are old men or women, and men, indeed. So how do we get into this space? So I always tell them, the most difficult one is to get the first case to be an arbitrator. Before you call yourself an arbitrator, you have not had a first case. Whether you are a fellow or a chartered arbitrator, it matters not. You need your first case. The first case can come from institutions. The SIC is one example. And with the streamlined expedited procedure, it's a great opportunity for them to try out young people. And that's how we hope to see, I believe it's also SIC's aspiration to see the new generation of younger people. I know a lot of young people here in this house. So it is a good opportunity for them.
So internationalize and keep your eyes open. Urvashi.
So I absolutely agree with my co-panelists here. I'll come back to the same point I was making earlier. E-filing, virtual hearings, VDR, case management, all of that solves for one thing for companies: cost and time. And honestly speaking, the entire, if you come to think of it, a startup in Bangalore or a mid-sized company in NCR, which would have not thought of getting into an international arbitration today, without actually incurring the cost of logistics, transport, and in fact, if the governing law is India, may also have an Indian lawyer who will be arguing your case sitting out of Delhi or Bangalore. So it has solved so many things for smaller enterprises, for startups. So it is an absolute welcome move. Thank you.
That takes me to the last person who's going to talk about the new gateway.
Thank you, VP. I began by talking about software and user interface. Gateway is our new user interface. And as you've heard, it's an e-filing system, it's a document management storage system. It comes from our realization that traditional means of storing the case record in an arbitration through your boxes and Google Drives and so on are not necessarily the most convenient, the most sustainable, the most secure, and may not be accessible after a certain number of months, etc. We wanted to create a mechanism and means, one, for parties to easily access filing. You can do that now through Gateway. You fill up a form, you play with an e-wallet if you need to, or a card, and then it goes into a universe of documents which becomes the case record for that arbitration, available to tribunals, available to parties, and at no additional cost to you. So again, like Mr. Chandrachud said, you cannot be a dictator, so we don't impose it on parties, but we look to persuade tribunals to use Gateway on their cases. We look to persuade parties to use Gateway on their cases because it provides you a seamless means of digitizing the case record and accessing it on the go through the course of the arbitration. And it really goes back to our efforts at digitization. Right from 2014, I don't think we have printed a single submission correspondence at SIAC at all. We do not require hard copy submissions. Everything is done electronically, internally, and in our external interface with parties. And Gateway is a further evolution of that. Since 2020, we've had guidelines and guides on conducting virtual hearings, which COVID has taught us works just as well, maybe even better in some situations. So for us, digitization is necessary, it's inevitable, but it's also, I think, a component of sustainability and environmental sustainability. The new rules, in fact, contain a queue for tribunals to raise the question of environmental sustainability at the first case management conference with parties and say what methods can we adopt that would be environmentally sustainable, whether it's virtual hearings, whether it's paperless case record, whether it's using Gateway. We leave that to parties and tribunals to figure out. But again, it's our cue of saying this is what is best practice.
So irrespective of whether you like technology or not, you definitely don't like paying for real estate. So at least from that perspective, ensure that technology becomes the new innovation in your life. With that, I'd like to thank the entire panel for their incisive experience sharing, and I don't know whether we have time for questions because I'm getting dirts from the lady in front. If there are any questions, we can open it out, maybe 2 questions. There's one here, there's one here.
I'll be very quick. I'm Pavli Reddy from Clarendon, London. In terms of innovation in the arbitration space, I feel that there is a need for the arbitrators sometimes. No disrespect, I mean, we all sit with the esteemed member of arbitral tribunals. When it comes to technology, I think sometimes they forget that the dispute they have in front of them is a multi-billion value. And the technology plays such an important role because gone are the days when you would turn a page and you will see when you go back home, you can look at the file, you get your assistant to look at the file and look at it. But now technology has advanced so much that I feel that arbitration institutions, if they can spend some more money or effort, in fact, to get all the arbitrators to do a minimum required course, they can manage that. Because that way it will save so much time. Not that I'm saying they have to be adapted with every technology coming into the industry, but at least to the basic requirements. So that will save a lot of time and also assist the parties because sometimes you get nervous the arbitrator may not be getting the point that if it's a disclosure application and we're talking about billions you had when your search terms, we have to search the data, and you're using this AI to search the data, and you use certain features. If the arbitrator is not getting your point, then you get really worried because there is a lot at stake. So I would be very happy if you have any views or how we can do that.
Apropos this this intervention, may I make a suggestion both to Professor Wu, which is that now different arbitral institutions are deploying technology on their own. We don't have a unified technology between LCRA or SIAC or ICC, actually, or the PCA. It might be a good idea now that especially SIAC is adopting technology in such a big way with Gateway to put out very simple tutorials. Tutorials for arbitrators, tutorials for the users, and a tutorial for the lawyers, which would just make it very simple to understand on what the essential features of the gateway are. I'm sure you're already thinking of doing it, or you've done it already.
They're on YouTube.
And I think that would be a very nice idea. And perhaps then take this to the next level, which is to the law schools. Why don't we sort of get some of the arbitral institutions to start talking to the law schools and get the young lawyers to be on the interface of technology? Just a suggestion.
Thank you so much. One observation I had, I'm sorry, after that I'll close this. On inclusion, I couldn't agree more with Justice Chandrachud. Inclusion of women. Now, I'm not a feminist, but I think there is so much need about inclusion. One example I would like to share, I went to a jurisdiction. It was a massive case involving billions when we were in a boardroom. Unfortunately, I was the only woman. I was very happy about that, but I had to use the restroom, and I said, where can I use the restroom? And they looked at me. Unfortunately, we only had it on the second floor for women, and I was on the 15th floor. So you can imagine, every company nowadays, whoever wants to invest in a company, the first thing they look at is how inclusive you are, how innovative the company is. So if a company is ignoring women and innovation, honestly, you are not looking at very good at innovation. So, or investment into the company. So those are the two things I wanted to share. Thank you.
See your hand, but I can see lights.
One at the back, now you can fight who's going to ask. Or you can split it.
I'll let the young man speak first.
Thank you. Hi, my name is Lakshmi, and my question was use of the AI not only as the support to the legal practitioners, but AI stepping into the shoes of decision makers. For example, ICC recently announced that it is looking forward to use AI as an arbitrator in construction matters with document-only construction arbitrations. So I would love to hear the view of the panel about this development and what are the possible implications about this. Thank you.
I was going to say we could be here all day. We wanted to talk about that. Maybe we should take that offline. I believe it was the ICBR that introduced what you were referring to.
Of course, we are, when we talk about AI in international arbitration, one will be careful as to whether the AI is substituting the arbitrator. But I want to pick up your suggestion that if parties really want to use AI, it does not, I see no issue with both parties to use their best submission and agree on a particular provider of the generative AI and upload it and agree on the solution to be binding between them. So there shouldn't be any bar against that. But of course, we in arbitration, we believe that we human beings need to have, when we use AI, it must be limited to certain functions and not one that generates the solution. So we have to be careful about that. Thank you.
I completely agree because AI, the deployment of AI would be governed by basic principles of party autonomy. If both the parties agree that we would rather have an expeditious decision by AI, whatever, 2.5 or 5.0, so be it, parties agree to it. But another very interesting area which we can really think of is predictive analysis. After pleadings are complete and parties have maybe even filed some of their basic evidence, could an AI-assisted model not tell parties what is likely to be the conclusion on the basis of the record to facilitate parties to decide as to whether to settle? What is the likely trajectory of this case, within limits of course, and then the party may decide, well, this is what it is based on a database. It might be worthwhile for me to explore the possibility of a settlement, and what should be the parameters of the settlement. Both parties can possibly have access to a possible settlement of the dispute based on what AI would predict as a likely outcome of the arbitration.
The difficulty of that is it depends on which one they can agree to. Just Mundi or whatever, or Pilot, whatever program the provider of AI is, because each have their own biases depending on the data they fill in. So that is the real problem. If they can agree on that, that's fine. And whatever solution they find, it will be bound by. They should be.
And I think we should call it quits because I am seriously getting you. We'll take it offline, I promise. Thank you everyone. I think we are holding you back from coffee. We remain available to ask any questions. But before you leave the room, I'd like to thank my panelists. It's been a fabulous session.